Hello everyone, welcome to today's video on the Australian Constitution. So we're going to practice writing some notes as if we were getting our exam notes ready or our notes for our test ready. So I've got some basic questions in my Word document already. So we've got background to the Australian Constitution. We have what is a constitution, what does the Constitution cover, and how can the Constitution be changed? Now, obviously, this is not an extensive or exhaustive little video, so if you have more questions, please let me know. It's just to get you started on the basics. So obviously, if you are not a first-year law student or you are not looking for a basics video, this is not the video for you. We are keeping things rather simple. So let's start. We're not going to start at the top. We're going to mix things up. We're going to start with what is a constitution. So a national constitution is a set of rules for governing a country. So let's write that down. Such rules may be based on tradition or may be written down in the form of a law or a number of laws. Now, in some countries, laws forming the constitution are ordinary laws, which may be charged just like any other law. But in most countries, the laws forming the constitution have a special status, and that's the same in Australia. So the Constitution of Australia has a special status. It cannot be changed in the same way as other laws can be changed, and it is a supreme law. That is, it overrides other laws. So that's the basics. What is a constitution? So now let's delve into the background of our system, because it's not just a constitution document, it is a system. So law and government in Australia are based on a constitutional framework, which is why it's so important. This framework is essentially the product of the British legal system, which was required by the developing colonies. So in 1788, so let's write that down, 1788, when Captain Arthur Phillip claimed, and this is the important part, terra australis. Let me make sure I'm spelling that right. There we go. For the British Crown, the reason that British law applied, and we know that still to this day, we do look to what the courts over in the UK are doing, and that really stems from this moment. The reason that the British law applied was because the colony was classified as settled rather than conquered or ceded. And that's a debate for another day. We're not getting into that. We're just keeping the facts on the Australian Constitution. So I do note this though, because this classification was crucial as it was the basis upon which the recognition or otherwise of the Indigenous people was decided. And there is lots of really great material available online and at the library about this if you would like to read into it more, or I'm happy to do another video as well, but that needs its own time in itself. So if a colony were classified as settled, there was no recognition of any pre-existing system of law. So no recognition of any pre-existing system of law. The Australian continent was considered uninhabited, and the first system of law to be applied was the British system. If, on the other hand, a colony were classified as conquered or ceded, the Indigenous people's pre-existing legal system was implicitly recognised as operating at the time of conquest. A major criteria for the classification of colonies was whether crops were cultivated. So that's what they were mainly basing it on. So Australia was classified as uninhabited, available to be settled, and as a consequence, the British law applied. This is not to say that the Aborigines did not have a system of law, rather that the Europeans failed to recognise and understand the complex system of law which governed the relationship between and within groups and ruled the vital relationships between the people and the land. So as a settled country, all the British law, both statute and common law, relevant to the new colonies applied. So we're going to take note of that as well, because that's important when we're looking at our, as a settled country, all the British law, both statute and common law, relevant to the new colonies applied. And that is why, to this day, we're still looking to the UK decisions when the Australian courts haven't dealt with something before. Now, we do have an important case here, so let's have a look at Mabo. So I'm going to put the full citation in for those who want to have a look and do some research. So versus the state of Queensland, 1992, the High Court overturned the concept that no previous system of land title existed before European settlement. So that is huge. So the High Court, let's take note, overturned the concept that no previous system of land title existed before European settlement. And we have to make note, in 1788, they were judging it on were there crops, which is why they said no system of land title existed. And then in 1992, they said, actually, that was incorrect. So it recognised the native title of a group of Torres Strait Islanders who could establish a direct and continuous association with their land since before European. Oops. Whoa, we have a few errors here. Wow, I am zooming along. Right. 4 years later, in the case of the Wick against the state of Queensland, so I'm going to write that one down too for those who would like to have a look at that. And that is in 1996. The principle in the Mabo case was extended. So extended the Mabo case when the High Court recognised for the first time the native title of another Aboriginal group to an area which had been subject to a pastoral lease where there was no inconsistency between the two forms of landholding. So that is also very important, and just consistency. There we go. So following the decision in Mabo's case, the Commonwealth Government passed the Native Title Act, led to the passing of the Native Title Act 1993, and that is a Commonwealth Act which established a tribunal and court process to investigate claims of native title and to provide compensation where the legislation resulted in the loss of native title. So this legislation was further amended after the Wick decision. Now, as we move along, the growth of the colonies and the distance from England created pressures for different governments and legal systems, and eventually each settlement was regarded as substantially independent with power to make its own laws for the peace, welfare and good government of its people. So up until this point, we've just been following the British laws. Economic factors, as well as fear of invasion by other nations, were instrumental in a push towards unification of the colonies. And after a series of constitutional conventions in the 1890s, Australia became a nation on the 1st of January, 1901. So let's write that one down. Australia became a nation on the 1st of January, 1901. So the Commonwealth Constitution is contained in an Act of the British Parliament passed in 1900, which sets out the terms of agreement reached between the Australian colonies for an Australia-wide federation. It establishes the Commonwealth Parliament, government, and the federal court system, and it also limits lists of powers of the Commonwealth Parliament along the defences, fishery. We've got state limits. It deals with currency, coinage. We're going to go into what it covers down here. So we won't move on too much into that. And then another thing is state versus federal laws. That is important too. And we will get down into that in a second. So what does the Constitution cover? So we have chapter 1, the Parliament. So this chapter, which is the longest, covers the structure and powers of the federal Parliament. So let's write that one down. This way you can sort of have your almost like a contents page, and I highly recommend you can either download it or buy it. It's quite small, the Constitution, a little A5 book, and you can have that with you in your exam or note, when you're doing your study for this subject, and you can quickly look it out, have things tabbed. So chapter 1, the Parliament, covers the structure and powers of the federal Parliament. And this also includes things like, so it has the general, legislative / law making powers of the Commonwealth. Now, this is held by the federal Parliament, consisting of 2 houses, the Senate and the House of Representatives, and the Queen, who is represented by the Governor-General. It also covers the appointment of the Governor-General and the Governor-General's powers to summon and dissolve Parliament. Then we also have the Senate. So it has the composition of the Senate. So each state is represented equally, and there must be at least 6 senators from each state. The Parliament may make laws setting out how senators are elected and also to change the number of senators. So there used to be 12 from each state, things like that. Then we have the frequency of elections. Let's add that in. So these are all things that we take for granted now, and it comes from the Constitution. Then we've got the House of Representatives. So representatives. I'm going to have to zoom in over this or else we're going to be going way too long. But it's got the composition of the House of Representatives and again, frequency of elections, etc., etc. Then we've got both houses of Parliament, things like matters disqualifying members and senators, the settling of disputed elections, parliamentary privilege, etc., etc. We've also got powers of the Parliament. So let's add that in. And things like the matters on which the Commonwealth can make laws. So that is huge. On which the Commonwealth can make laws. So the federal Parliament can only make laws on certain matters. And remember, Commonwealth laws affect all of Australia, so they don't have the ability to legislate on everything, which is why we have different states and territories with different legislation on very similar things. So some of the things include, and again, I would just have this tabbed in your little Constitution book or just download it, but we've got international and interstate trade, foreign affairs, defence, immigration, taxation, banking, insurance, marriage and divorce, currency, weights, measures, post and telecommunications, pensions, and then, so actually I'm going to copy and paste that in so that we've, e.g., let's add that in now. Okay, so that's in there like so. Now we must take note that on some matters, the Commonwealth is given exclusive powers. So on some specific items, the states and territories are not able to legislate in these areas. And on other matters, the Commonwealth and the states have what are called concurrent powers. So that is both the Commonwealth and the states may legislate. So what you need to make sure in your notes, make note, what can the Commonwealth legislate on? What can the states legislate on? What can they both legislate on? Really important to make sure that you know where to look for that information. So you don't have to memorize everything, but it's important to know where to look just in case it comes up in an exam question or a problem question. Now, the states retain legislative powers over matters not specifically listed in the Constitution. And again, we need to make sure that we're across that, but we don't have the time to be going into that in this particular video. So we're going to move along now to chapter 2, which is the executive government. This covers things like the structure and powers of the executive government. So we've got the things like the Governor General, Federal Executive Council, there's no for that. Council, appointment of ministers, etc., creation of government departments. Then we have chapter 3, and this is a really important chapter. So we know that the Constitution helps create the separation of powers, and this is all part of it. So it's got the structure and powers of the federal judicial system. So we have the establishment and the jurisdiction of the High Court, of the High Court. We know how to create other federal courts. We have appointment of judges, etc., etc., etc. Things like guarantee of trial by jury for specific offences against Commonwealth law. Things like that are found in chapter 3. Then we have chapter 4, which is finance and trade. So this is Commonwealth finances and trade between the states. So Commonwealth finances and trade between states. We have things like federal parliament's control over Commonwealth spending, Commonwealth control of customs, free trade between the states, and the Commonwealth powers to give financial assistance to the states. Then in chapter 5, we have the states, and this is the relations of the states with the Commonwealth. So the relations of the states with the Commonwealth. So that is things like the states keep the same constitutions, powers and laws as they had prior to federation, except as modified by the Australian Constitution. And then we have, in cases of conflict, in areas where the Commonwealth and states have concurrent powers to make laws. So we know that some laws they can both legislate on. When they both legislate on the same law, the Commonwealth law has priority. Commonwealth law has priority, and the state law is invalid to the extent of any of the inconsistency, where both Commonwealth and state have concurrent powers to make laws. And that's chapter 5 Constitution. Excellent. So we just need to make note of that because that does come up quite often in problem questions. What happens when the Commonwealth and the state legislate on the same thing and they complement each other? We're fine. Business as usual, carry on. If they are inconsistent or they clash or they can't be read together and everyone's happy families, then the Commonwealth law takes priorities. Then we have other things that are in chapter 5, We've got conflict. The states may give power over to the Commonwealth if there's something they want them to legislate on behalf. The Commonwealth is prevented from passing laws to establish any religion. So they cannot make a national religion. Then we have, we've got chapter 6. That's on new states. So this deals with the creation of new states and gives the Commonwealth power to make laws for the government and representation of the territories. So that's important. We have chapter 7, which is just miscellaneous. I shouldn't say just, because it's not just. And that covers the establishment of the seat of government. So that is the Australian Capital Territory, and allows the Governor-General to appoint deputies to exercise powers or functions in his or her behalf. So establishes the ACT. I should note here, let's just do this properly. Creation of new states. It's the Commonwealth power to make laws for the government and representation of the territories. There we go. All right, then we have chapter 8, which is alteration of the Constitution. And that sets out how the Constitution may be changed, which we can go into detail now. So we know, so there are some matters that aren't in the Constitution, and we can get into that. We know that the High Court interprets the Constitution. So let's add that in up here. High Court interprets the Constitution. So the High Court only needs to do this when a specific case is before the court requiring a ruling on a provision of the Constitution. So it doesn't give advisory opinions, but sometimes there might be a disagreement over the meaning or application of a particular provision. Or, for example, there may be developments which were not foreseen when the Constitution was written. A classic example of that is aviation and television. Those things weren't around, they weren't foreseen, and the High Court has said, hey, look, this can be included in this section or that section, and that's our interpretation. So through interpretation, the effect of the Constitution has been changed over the years, and many of the court's rulings have had the result of extending the power of the Commonwealth, but they do not change the Constitution. So let's go down. How can the Constitution be changed? Ooh, here we go. So the Parliament can change ordinary laws by amending laws, but it can only initiate proposals for changes to the Constitution. So the states and the Parliament cannot change the Constitution themselves. They can only initiate a proposal. So we've seen over the years there have been several attempts to change the Constitution, but the approval of the people of Australia is necessary. So the approval of the people of Australia is necessary for any change to the Constitution. Parliament can propose a change, but not push it through themselves. And that's just the same as the approval of the new people of Australia was required in the process of creating the Constitution in the first place. So the Constitution sets out the way in which it can be changed. So I'm just going to write the way in which it can be changed. A proposal to alter the Constitution starts as a bill, so process brief. We're going to keep this very brief. That's another video in itself, but starts as a bill in either House of the Parliament and can be introduced by any member or senator. A constitution alteration bill goes through the same stages and follows the same procedures in each house as any other bill. And I can do a video on making laws if that's something people want to see. With the important exception that its third reading must be passed by an absolute majority. So let's write that one down. Third reading, must be passed by an absolute majority. An absolute majority means that it must be agreed to by more than half of the total number of members of the House. Other bills need only the agreement of the majority of members voting at the time, which is called a simple majority. When a constitution alteration bill has passed both houses, it is voted on by the people of Australia. So passes both houses, voted on by people of Australia in a referendum, And that has to be held after 2 months, but within 6 months. To save expense, referendums are usually held at the same time as elections for the House of Representatives and or Senate. A constitution alteration bill does not have to be passed by both houses of Parliament. If one house refuses to pass a constitution alteration bill which has been passed by another house, the bill may be submitted to a referendum if the first house passes the bill a second time. To be successful, the proposal must be approved by the majority of voters nationwide. So must be approved by the majority of voters nationwide and also by the majority of voters in the majority of states. So this is where you see those polls on TV, and also by the majority of voters in the majority of the states, e.g. at least 4 states. If a proposal affects an individual state rather than all states generally, the proposal must also obtain majority approval in the state concerned. So many have been discussed over the years, but most have not gone as far as referendum or have been rejected at referendum. There have been 44 proposals to alter the Constitution which have been passed by the Parliament and submitted to referendum, but only 8 have been successful. And we're not going to take note of these, but to give you an idea, some of them are the Commonwealth can take over state debts. The Commonwealth can make agreements with the states about the state's public debts and borrowing. Power to legislate on a range of social services was given to the Commonwealth. There were let electors in the territories vote in referendums. So that only happened in 1977. They set a retiring age of 70 for High Court and Federal Court judges. Those are the sorts of things that have been pushed through. Then obviously we do have the most recent, which is the Voice to Parliament and the Uluru Statement. So the Uluru Statement from the Heart, drafted and endorsed at the National First Nations Constitutional Convention in 2017, called for the establishment of a First Nations voice to be enshrined in the Constitution. And obviously, we know that voting happened on this. I'm not going to get into that in today's video because this is just about the Constitution. But if you'd like to see a video on that, or you'd like to see a video on any more questions that you have about the Commonwealth, how it works, or any of the particular parts, please let me know. That this is what your rough notes should start looking like as you go through your lecture slides and go through your readings for the Constitution. Really, you want to make sure you know what each chapter of the Constitution is trying to achieve for Australia and where you need to go if you find a question. So really use the Constitution as your guidebook. And a question again might pop up about states versus Commonwealth if there's an inconsistency, or often a question will come up with about can the states legislate on this? So you need to know what section to go to, or the powers of the territories, how did they get their powers, etc., etc. So please make sure that you go through your notes, have it covered, feel confident about the Constitution, but remember you do not need to memorize the Constitution. You just need to know where to look for your information. As always, if you have any more questions, please let me know and I'd be happy to make another video for you.